Hi, everyone. Thank you for joining us today. I'm calling to order this meeting of the Cleveland Heights City Council Housing and Building meeting at 4:31 p.m. on Tuesday, June 11th. Clerk Ballister, if you wouldn't mind, could you please call the roll?
Petrus.
Here.
Larson.
Here in Zoom.
And Maddox.
Here. Great. Thank you so much. So just to overview today's agenda, we have Elizabeth Zach and Matt Venzel with us from the Legal Aid Society. So they have drafted a Cleveland Heights specific list of rights and responsibilities for tenants, and they're going to overview that for us today. And we'll be able to ask them questions as they're going through it. And then after that, the law director is going to go through maybe some of the mechanisms that we might be able to use to get this out to folks if we were to pass this. And
or
then
potentially to ask questions about that.
yeah, okay. And then finally, we're going to talk just briefly about some of the recommendations from the Racial Justice Task Force. So with that, Elizabeth, could I turn it over to you and Matt?
Yes, thank you, everyone. And go ahead, Matt.
Yeah, so I'll get us started if that's okay. We were really excited to get the chance to collaborate on this. We, at Legal Aid, we are constantly making efforts to try to educate tenants. We have Know Your Rights presentations. We are frequently out in the community trying to let folks know what their rights are, but we have a tenant information line that people can call into, but we can never really fully meet the demand because we continue to see folks coming to us who clearly are not aware of their rights and also are not aware of their responsibilities. So when Mr. Petrus came to us with this possibility, we were really excited, and we tried to draft something that is sort of kind of a middle of the road approach. This is certainly not something that can fit on a trifold brochure that can be handed out. And I don't think it's really possible to approach this kind of a project from that perspective. But it's also not, a 60-page document. One of the things we included in the materials is a link to what Seattle uses. So the city of Seattle has a tenant information guide that's almost, I think, like 56 pages long. We could certainly, if council is interested in that, that's certainly something we could do, but we tried to tone it down a little bit. So the way we approached it is to try to go through sort of a timeline of a tenancy. And we thought it would be easier for tenants to access this if they were looking at what their rights and responsibilities are before they rent. So when they're searching for property to rent, what their rights and responsibilities are while they're renting, and then what their rights and responsibilities are after they terminate the tenancy and move on from the tenancy relationship. So that's the way we set this up. There certainly could be other approaches, and we're open to those if you'd like us to be, but we thought it was important to talk about rights and responsibilities because I think we see tenants coming to us, like say, for example, we get lots of folks who come to us who don't realize the extent of their rights related to having their landlord maintain the property in a safe and habitable condition. We see lots of folks who don't have knowledge of their rights. We see just as many folks who, in that same situation, just stop paying their rent, right? Which is not something that under Ohio law you can do. So they're not aware of that responsibility. So, and that's just one example. So we thought it would be helpful to set it up that way so that tenants understand what they have the right to do and what they're entitled to under landlord-tenant law, and then what responsibilities they have to maintain. And so I think Elizabeth is going to sort of go through, if it's okay with you, just sort of go through each section and highlight some of the important rights and responsibilities we've laid out.
Great, that works for us. Thank you.
Okay. And is this something that people would like me to screen share on Zoom, or do you have your own versions where you'd like to follow on your own?
I have a copy in front of me, but in case anyone is watching over YouTube, it might be helpful if you were to share your screen.
Oh, we're on YouTube. Okay. Okay, very good. Let me do that. Okay, and so hopefully, and I will zoom in, but hopefully you can see this document now?
Yes.
Okay, very good. So I will say, if anyone has any questions, Matt and I are both available to stick around. And also, if you want to interrupt me with any questions, that is perfectly fine as well.
Elizabeth, I'm sorry, I think you're sharing a different screen right now.
Oh, I sure am. Okay, sorry about that.
No problem.
I know.
It was there just for a second.
Split the screen. Okay, sorry about that. So hopefully this is back on proposed scope of tenants' rights and responsibilities. Okay. All right. Okay, so Matt just discussed the scope, and so what we have laid out here is kind of almost an outline, like as if you were a student, and so we're not by any means married to this format, but this seems like perhaps the cleanest way to convey this information to everyone. And so before you rent, in terms of rights, there are fair housing rights that we'd like tenants to be aware of, and especially in light of the Cleveland Heights ordinance that protects tenants based on their source of income. That was a wonderful protection that council passed somewhat recently. And what we're finding when we're talking to tenants who have vouchers either through Eden or through the Cuyahoga Metropolitan Housing Authority is that they don't necessarily know that there are these couple of municipalities within Cuyahoga County that are really supposed to be a safe haven for people with vouchers. So we're trying to get that information out there. I know the Fair Housing Center for Rights and for Research and Rights is trying to get that information out there. But it's still a little bit of an information battle. So here we included not only the federal and state protected classes, but again, the source of income. And so we have citations to those. We included information about a tenant's right to request a reasonable accommodation or a reasonable modification. And sometimes tenants might not realize that it could actually be their responsibility in non-subsidized housing to pay for example, that wheelchair ramp or the shower grab bar. We made sure to specify there. Then here we're really trying to encourage tenants to protect themselves against scams and to start their lease off on the right foot, start their tenancy off on the right foot by reviewing that lease ahead of time. We encourage tenants to get a copy of that signed lease. They also should be hopefully looking at the unit that they're actually about to rent. I know a lot of landlords have like a model unit, and that's certainly fine for kind of getting your first look at a building, but when it's time for you to actually sign the lease, you should be looking at the property that you are about to rent. It's in Ohio law that tenants have the right to know the name and address of the actual property owner and the property manager, if there is one. And tenants are entitled to signed receipts from their landlords anytime there's a security deposit payment that's made. And that is actually part of the pay to stay ordinance that was passed. So again, kudos to City Council. That's a Cleveland Heights specific right that we want to make sure Cleveland Heights tenants know about. And regarding lead safety, again, tenants have the right to live in a unit that has a lead safe certification. And so again, that's another Cleveland Heights ordinance. And the federal law is that they also have the right to receive that EPA pamphlet that a lot of landlords with properties prior to 1978 have. In terms of responsibilities, the housing search is really a rights heavy phase in the, I guess, housing timeline. So we have one responsibility here. We do want tenants to know that they must provide truthful answers on rental applications. That's something that could potentially come up down the road. Sometimes a landlord will discover, for example, that a tenant did not disclose a former eviction, and we wouldn't want that to interfere with the tenant's tenancy down the line. So that is the pre-rental stage. Does anyone have any questions about any of those rights or responsibilities?
Council President.
Yeah, so it seems like it would be a good idea to have a section in here that is like, I don't know, suggested practices or something. Because it's always a good idea to take pictures before of the property. Now, I understand it's not a right and it's not technically a responsibility, but I put this under good ideas. So you take pictures of every room, make sure you try all the utilities to make sure they work. This way, if you ever get accused of breaking something, through what the landlord might call negligence, you have some proof that you didn't make that hole in the wall, or the refrigerator looked like this when you rented it. The other thing is, with regard to the lease, I think it's important to, in the before you rent stage, to urge a new tenant before they sign a lease to obviously read it, which you did, and then ask questions about anything they don't understand in the lease. And if there's anything that they still don't understand, it's always good to consult an attorney or somebody, with a legal background, because even though you can't technically sign your rights away, let's say a landlord says, tenant makes all repairs. You could sign it and it's unenforceable, but there might be something in there that, you would be giving away that you might, if you didn't understand it, and it's always good to ask questions. So I would just add some best practice. I don't know what you want to call it, but, it's a good idea to do these things before you sign a lease.
And Elizabeth and Matt, I'd just like to note that our Mayor Khalil Sarin is in the room with us today. Thank you, Mayor. If you'd like, you're welcome to join us here at the table. Great. Any other questions?
Well, Councilman Kuda, I like those suggestions, and even the simple suggestion of asking any questions now, just to get some clarity. I like that. One of the things that we see somewhat regularly is confusion around utilities. Tenants will agree that, sure, they're responsible for paying the water and the sewer, but they don't necessarily realize that the city of Cleveland Heights sends its own maintenance sewer, storm sewer bill that is separate from the regional sewer district sewer bill. Does sewer mean both? Are they responsible for both? Are they responsible for getting the water bill in their own name? If so, the Cleveland Division of Water will charge tenants, I believe it's a $400 non-refundable fee. Matt, you know more about that than me, but that would be something where we would want tenants to ask the landlord up front, and is there some kind of rent or security deposit credit they could maybe negotiate if they're going to have to pay out that money. So anyways, you're giving us more good ideas, which I appreciate.
Any other questions in the room before Elizabeth proceeds? Okay, I think we're good, Elizabeth.
Okay, great. So now you signed the lease, you've moved in, and while you are renting as a tenant, you still have fair housing rights. So again, you still have the right to not be discriminated against. And again, that source of income discrimination that is specific to Cleveland Heights, that carries over throughout the duration of the tenancy. So if a tenant should be fortunate enough to receive a housing choice voucher while they are living in a Cleveland Heights rental property, then again, they could utilize that voucher while they are there. And again, tenants have the rights to request reasonable accommodations or modifications. We have the citations for those there. Okay, the biggest section, the largest part here is really about conditions. And so,
Elizabeth, if I could, it looks like Councilwoman Larson has a question.
oh, sure.
Thank you, Elizabeth. I'm just curious about the reasonable accommodations aspect. I would think that that would have to be well documented when it occurs, that the tenant requests in writing or some way that it can be documented. They made that request and then you have verification that it's not complied with, especially we're talking about ADA compliance. So how does that work?
Yeah, so Councilwoman Larson, I agree. I'd say that almost falls under the idea of a best practice, or if we were to have like a good ideas section, because really a reasonable accommodation can be made verbally. I don't recommend it, and I would want a tenant to document it.
Yeah.
That would be a good suggestion. Document, put it in writing, save a copy.
All right, thank you.
All right, a lot going on with conditions here. This is also the largest part of the actual Landlord Tenant Act in Chapter 5321 of the revised code as well. So tenants have a lot of rights related to conditions. Some of them it might seem obvious. Of course, the landlord has to comply with all applicable local codes. The tenant has the right to have the landlord make the repair and do whatever is reasonably necessary to keep that property in good condition. Number 3 is not always obvious to tenants. The landlord is responsible for the common area of the premises as well. So sometimes we hear from tenants where they don't feel safe in stairwells, or a light bulb has burned out, or the light is not connected to any one individual unit's electricity. And so the landlord has the responsibility for that area as well. That extends to parking lots, landscaping. The tenant, of course, has the right to live in a unit where all of the electrical, plumbing, sanitary heating, AC, etc., is all functioning. This next one, number 5, the tenant has the right to electricity, running water, reasonable amounts of hot water, that's straight from the revised code, and reasonable heat at all times. At all times actually means even if the tenant is behind in rent. And that's something I debated including here. And so I'm just letting everyone here know that sometimes we see cases where a tenant is a little behind on the rent, a lot behind on the rent, and instead of filing an eviction in Cleveland Heights Municipal Court, the landlord is taking matters into their own hand and, well, if I turn off the electricity, surely they'll get out. So I don't know if that's something that we want to specify there, but the tenant has the right to those basic utilities, water, heat, electricity, regardless of their payment status. The only exception is the second clause here, unless the utility account is actually in the tenant's own name and the utility company, the illuminating company, has shut off the lights because the tenant has not kept up with their own personal bill. So that's kind of a tricky one to parse out there, but that's what's going on behind number 5. All right, so 6, 7, and 8, and then of course 9 relate to retaliation. Landlords are not allowed to retaliate against tenants if the tenant complains to a governmental agency or the city about the conditions. The the landlord is not allowed to retaliate if the tenant actually starts talking to their neighbors and either forms a tenants association formally or just informally, writes a petition, something like that, writes a letter that a couple tenants sign. A landlord cannot retaliate against a tenant in that sense. Retaliation could be raising the rent, could be giving a notice to leave, it could be filing an eviction, or it could just be threatening that they're going to do any of those things. And then if a retaliatory situation comes up, that can be used, and that's number 9, as a defense in an eviction. Okay. So tenants, I'm looking at number 10, have the right to request in writing that a landlord fix
I'm sorry.
conditions in the premises. Oh, and I see Councilwoman Larson, if you have a question, I can stop there.
Yes, I'm wondering if it'd be acceptable to specify at this point, what a government agency would be that they could reach out to, because if people are not aware of what their rights are and they're starting to look at this document carefully, is there a way to reference some government agency that they could actually reach out to on number 7?
That's a really good suggestion.
I think people need information, and that would be very helpful. Thank you.
Okay, I like that. All right, if there's any type of condition the tenant thinks the landlord is responsible for repairing, the tenant can request that be fixed and can request that in writing. That's number 10. And then the tenant might be in a position where they want to take that written notice from number 10 to the Cleveland Heights Municipal Court and then go ahead and deposit their rent. And so that is what Matt was referencing before. A lot of tenants are either, and we talked with Jim about this, a lot of tenants aren't aware of the rent depositing process or think that they can withhold. And it's confusing. Landlord-tenant law is different in different states. So I think people hear things from friends and relatives or see on the news. And rent withholding is a surefire way to get an eviction notice, unfortunately, in Ohio. So, and we did specify here, Cleveland Heights Municipal Court. Hopefully people know, that that's where they'd be headed if they were going to rent deposit. And then if they do rent deposit, they have the right, number 12, to ask the court to reduce rent or to allow the tenant to actually use that deposited rent to make the repair themselves. It depends on what the repair is, if that's going to be practical or not.
Elizabeth, am I remembering that a reasonable amount of time is generally understood to be 30 days?
Yes, it is. And so that's, okay, in number 11, what we could do is find a way to phrase that appropriately. I did not say 30 days here because there is a misnomer out there that the default is 30 days. And the statute is worded in a way that says, just as you said, 30 days is presumed to be reasonable, but by no means is 30 days required. If the electricity is off, if the refrigerator is totally broken and the landlord has communicated, I have no intention of fixing this, 30 days is not reasonable. And the local clerk of court should be accepting rent deposit. It's not their role to time check and see if 30 days has passed. 30 days is a suggestion in the statute. It's not mandatory. So I'm making a note here for number 11 that we find a good way to suggest 30 days, but make sure everyone knows it's not mandatory.
Okay.
I don't know that tenants use this option a lot, but instead of depositing their rent, when a landlord has not made a repair within the time requested, and again, depending on how severe that is, that's 30 days or maybe less, they also can use that as an opportunity to end their lease and just move out. So that's here, number 13. There are a few rights related to privacy. So tenants have a right to receive 24 hours notice unless there's some type of emergency. And the Landlord Tenant Act does say that tenants have the right to be free of repeated and unreasonable demands for entry. So the busybody landlord who wants to do a weekly inspection, that is not allowed.
Council President?
So I know you probably don't want to get into like minutia when you're writing these concise sentences, but you can tell the landlord, no, that's not a good day, but you have to offer them another time. I don't know like how much you want to get into that kind of stuff, but it's sometimes people don't do that. They just say no because there's tension or some other thing. And you on the responsibility side, you can't just say no. So I don't know where or if you'd want to put that in there, but I just thought I'd throw that out.
I believe we do have something like that in the responsibilities section.
Okay.
You are absolutely right. Yes, allow access to the unit.
Very good.
And so maybe this is, again, it depends on how long we want this document to be.
Mm-hmm.
But there's also another conceptualization of this is where it's divided by topic and rights and responsibilities are mixed together. Because here we have allow access to unit. You must allow your landlord to enter the unit to make repairs or improvements. And so that, is of course related to the right we were just talking about. So good point. All right. Oh, that's right. We were talking about notice and this next section, rent and pay to stay. We're kind of getting into the pre-eviction or eviction world with these sections. So another part of the revised code that deals with eviction in court says that tenants do have the right to receive a notice to leave at least 3 days before the landlord files an eviction against them. There are some other notices, like a tenant is required to get a 30-day notice before the landlord were to terminate the tenancy. If, for example, there was some type of violation related to the tenant not keeping up their end of the bargain. If the tenant is keeping trash in the yard or on the porch or something like that. So again, we didn't go into detail with all of the different types of notices. There are notices related to subsidized housing. That is a whole nother can of worms. But that's worth consideration, especially because I think Cleveland Heights does have quite a number of tenants with housing choice vouchers. So again, I can kind of type up some notes for follow-up if, again, we want to add some more notices. But the 3-day notice is required in every single scenario, regardless of the reason for the eviction and regardless of the kind of property. And so that seemed clear. Every tenant knows that needs to know that they're entitled to the 3-day. And then related to what I was saying before about when like a utility shutoff happens, and that's called a self-help eviction. Number 2 here says you have the right to stay in your unit unless your landlord has actually filed an eviction complaint in the municipal court. And after your hearing, the judge says you have to move. I think sometimes people get that 3-day notice that's mentioned in number 1 and think that 3 days, the bailiff is coming out. And if the tenant has a defense, we'll get into rent and pay to stay down here. The tenant might want to stick around on that 4th day and wait for the eviction to be filed so they can assert their defense. tenants in Ohio have the right to a trial by jury. We don't see it very often at all, but it's a right, and so it's there. And regarding rent and then Cleveland Heights pay to stay ordinance, tenants have the right to receive signed receipts for every payment unless they pay by personal check, which is becoming less and less common. And then the pay to stay ordinance also defines what reasonable late fees are, so that's very helpful. I don't know that a lot of landlords are abiding by that, I will say. So
I was just going to say that my own contract seems to be in violation of that, so I'm glad to see that there.
yes. Okay. All right. Let's see. And then pay to stay, 3 and 4. Tenants have the right to avoid the eviction filing for non-payment of rent so long as they've tendered all the past due rent and the reasonable late fees. And then if they don't make the tender by that point, or they made the tender and it was wrongly rejected, then they can assert that right in court. But if they're making the tender for the first time, they also, of course, need to include the landlord's court costs. And I did say here, but not attorney's fees, because that is a different part of the Landlord-Tenant Act that says a tenant cannot be held responsible for a landlord's attorney's fees.
Mr. Chairman,
Yes.
if I might, Elizabeth, I was just I'm Bill Hanna, I'm the law director, and I just wanted to put a little asterisk by 3 and 4, I guess. I'm not sure that I would sign on to the language that the tenant has the right to avoid the eviction filing, maybe so that nobody's misled, just because of the feature of that ordinance that you just mentioned, which is that if it's tendered, but the action is filed or the judgment is rendered, it's an affirmative defense to that filing. I'm not sure that necessarily translates in practice to avoiding the eviction judgment. So I just wouldn't want to mislead anyone. It might need to be revised to be a little more nuanced.
Mm-hmm. You're right. I agree. And avoid is not a very clear, powerful word. So we'll toy around with that one.
Sure.
Okay. All right, so now while the tenant is in the unit and renting, they do have a number of responsibilities. Many of them pertain to how the tenant actually maintains the unit. They have to keep it safe and sanitary. They have to use all of the electrical and fixtures and appliances properly. And the tenant or their guests are not permitted to disturb their neighbor's peaceful enjoyment of the premises. So that's important for tenants to know. Nothing further there. We talked about allowing access to the unit. It's also in the Landlord-Tenant Act that tenants are required to keep their guests and their household free of illegal drug use on the premises. And then every lease is going to be different. And so it's hard to tell a tenant specifically what their obligations are under the lease. But I think it's fair to advise a tenant that they must follow all the terms and rules in their lease, including paying your rent. So again, we're not trying to get into a rent withholding situation. So number 2, you must pay your rent even when your landlord has not made requested repairs by either paying your landlord directly or depositing your rent with the Cleveland Heights Municipal Court. And then if the tenant is month to month, they do have to give 30 days notice. Any questions on that before we talk about the end of the lease? All right, so this is simple, but again, this is a good scenario. This is a good place where there are maybe more suggestions that could further flesh out the rights and responsibilities here. So The tenant does have the right to receive the return of their security deposit, but that's minus any deductions for past due rent or damages beyond normal wear and tear. We don't see security deposits in excess of 1 month's rent very often, probably for this reason, because a landlord is required to put it in an interest-bearing account and provide 5% interest. So that sounds like something most landlords would like to avoid. And of course, the tenant does need to leave the unit in good condition minus normal wear and tear. So here, tenant should be taking photos. If the tenant is going to request the security deposit, they should really do it in writing. They should provide their forwarding address in writing. So those might be some suggested best practices. And then that's it for the rights section, but there are, as Matt said, we kind of like went down the middle here. There's 3 different samples that I thought might be helpful. This Seattle Renters Handbook, I provided the link in the footnotes if anyone wants to look at that later. It's beautiful. It's also like a novel. And so maybe we don't necessarily go big like Seattle. But for the law director Hannah here, I thought it might be helpful just to see how they actually have it structured. Like it is referenced within city ordinance. They specify that the landlord shall provide this specific handbook or the handbook designated by the city of Seattle at such and such web address, and then how that is enforced. And there's a couple levels of citations, and then it escalates to a criminal penalty if a landlord is found to not be providing that pamphlet. In Ohio, we have a list of 36 individual rights for nursing home residents. And that is a much more succinct document than the 5 pages here that are devoted to tenant rights and responsibilities. And there's different enforcement, but those rights are actually part of the Ohio Revised Code. So that would be, I think, that's a different mechanism that maybe is not what the city is looking for, like actually enumerating all of these specific rights and responsibilities, but that is another option. And then the federal lead warning statement that tenants have been receiving for many years now, that again is similar to how Seattle has it set up, where the EPA, I believe it's in the Code of Federal Regulations, references that the pamphlet designated by the EPA shall be provided, but it's a more condensed version. And then there's civil money penalties that are enforced if a landlord is found to not be providing that pamphlet. So the links are down there, and Matt and I are both happy to take questions.
Councilwoman Larson?
Thank you. Curious about the federal lead warning statement. There is a possibility when a lead test has been done in a unit that the occupants will be required to relocate. Is there anything in the federal lead warning statement or the Seattle Renters Handbook that addresses what their rights are should that happen?
I'm not recalling anything in the Seattle handbook. Matt, are you familiar with any?
No, I don't think that is in the federal pamphlet related to lead either. Because oftentimes those rights are state specific. So we could certainly provide a description of the rights that tenants have under those circumstances.
Okay.
They're not as well laid out as we'd like in state law, unfortunately. But
it's a difficult situation, I can imagine, from both the landlord's standpoint and the tenants. So should they be said, be said that there's so much damage that they have to leave. even if temporarily. So if you can find anything on that, I'd certainly appreciate it. Thank you.
Are there any other questions for Elizabeth or Matt? Yeah, Council President.
So I have another suggestion that doesn't fall under rights or responsibilities. It's always good for tenants to keep records and be encouraged to keep records. Keep a file like for your email exchanges with the landlord. If you have a phone conversation, keep a contemporaneous, write down, I call, because that's the tough one with, I called the landlord and I told him, blah, blah, blah. And they just write it down, date it, sign it, keep, make sure you have a copy for yourself. Basically you're you're this backstop for these people who, unfortunately run out of options, and they come to you. But sometimes if they do these things and the landlord knows it, and they know the tenant's on their game, sometimes it's a different story, so.
All right, I made a note of that, and yes, I agree. Keep a record of everything.
So Elizabeth and Matt, thank you so much again for compiling this draft for us. Really appreciate it. Here in Cleveland Heights, 43% of folks are renters. And so as I hear all the time, folks don't really oftentimes know their rights until they're in a difficult situation. And so I see this as something that could be really helpful for a lot of people. So I am very grateful for all of your work. So we are now going to transition to a part of the meeting where the law director could hopefully share with us maybe some of the mechanisms that we might be able to utilize to get this out. Would it be helpful if Elizabeth and Matt stayed on the call in case we had any questions for them?
It might be, yeah, if they have a few more minutes. And I think what I would say, Mr. Chairman, is that I've got, some comments and thoughts, having just reviewed this prior to the meeting, after receiving it from you. I think it's very well developed, and a lot of work obviously went into it, tailoring it to Cleveland Heights, which could be really useful. There's some tension between the two areas that I'm interested in here, which is on the one hand, like what is here and what's not here, and should there be something that speaks to landlord rights and obligations. And admittedly, some of my exposure to this subject matter and Ohio landlord tenant law in the past has been at CLEs and continuing legal education seminars and things of that nature. And so you usually see both halves presented, but one of the things that occurs to me is that it can be useful as a reminder to both sides, kind of to see how each of them is addressed in the landlord-tenant law, and maybe some speaking to their rights and responsibilities on either side of that relationship. And we have a lot of landlords, including small landlords in Cleveland Heights. So depending upon what council's objective is, I would just mention that. I wondered if a brief introductory statement or short paragraph about, not to disrupt or undo the outline format, because I think that's easy to follow and useful and makes the information accessible to a reader, but something about 5321 and how state law really governs this relationship, at least in the larger sense, and give people some context. And I don't know what the best way would be. You guys may be right that, and maybe these are mostly for council's reference, the footnoted sites. I think they're useful. They were useful to me. I don't know, what the most useful way to put that together for a reader might be. But then all of that gets into sort of the question about methods of dissemination. And one method, I haven't looked, I think Seattle's in the far northwest part of Ohio, right? Just kidding. I haven't looked at Ohio law to see how that holds up here and whether that's something that we can compel. I'm not certain that we can't. I just haven't looked at that, but that's something that could be researched and pinned down. Certainly materials could be made available at City Hall. I feel like there might be advantages from a currency standpoint to trying to house as much of this information as possible on a city's website. Because if it turns out there are ways that council or staff, et cetera, determine something could be better explained or better said, or we see something happen in one of the pay to stay actions that have worked their way through the courts, and we feel like this information ought to be updated, can very easily be done if it's housed on the city's website. Whereas if you need to update it to people who've already received it, or print new pamphlets, et cetera, it's harder to do. So we can look at, if council's interested in moving forward, again, our ability to compel landlords to provide this. I don't know if there would be pushback. There might, but we also could look at either a voluntary action by the administration if they wanted to sign on to make this available on the website or at City Hall, or an ordinance that says that this will be made available on the city's website. And that information will be, copies of this will be available in the housing department, something like that. Again, just having looked at this and then hearing the explanation, which was very helpful, I feel like this is always a little bit of a moving target. So I shared some of my thoughts about content. And then I do feel like there could be real benefits to having the ability to edit in real time as circumstances dictate. So,
Yeah,
that's Chairman.
certainly seems beneficial that if we were to put it on the website, we'd have the flexibility of being able to edit it. I do want to explore the possibilities of potentially distributing this through landlords to people. I know that whenever I signed my own lease, there was information, for example, about lead and bed bugs and other things. And that's a time whenever you're reading that pretty closely. And so that seems, and I understand that some of this information is more relevant before you actually sign a lease. But that seems like a really good time to get it into someone's hands. And it seems like they'd be more likely to actually read and digest that and internalize it rather than if it were just passively placed on the city's website. And maybe it's a case that we could do both.
Both. That's what I was going to say. Because that makes sense. But you could also include a statement that says, this information can also be found here and is regularly updated, et cetera.
So at least knowing what the options are, I think that would probably be helpful to the committee so that we could then, talk about different ways that we might want to proceed with it.
Okay.
How do other folks feel? Does that sound like a good approach? The law department could do some research and then get back to us on potential ways that we might be able to disseminate this. Councilman Maddox, Councilman Larson.
Either way.
Sure, I'll go ahead and say that sounds like a very reasonable approach. Absolutely.
Okay. Is there anything, so I guess in terms of next steps, so if you wouldn't mind taking a look at this and then maybe for our next meeting, which would be at the beginning of August, sharing with us what you learn, and then we might be able to have a better discussion about how we'd want to proceed, whether we want to draft legislation or maybe just like you suggested, see if the administration might be willing to put it on the website. We could decide which approach at that point we want to pursue. Is there anything else? Councilwoman Larson?
Yes, before that meeting, could we get a copy of the draft to look at before we head into that meeting in August, please?
Like a draft of the potential ways to disseminate it?
No. Tenants' rights, the whole document we've been talking about today.
Well, I think that this is the document. And
Okay.
I think, maybe it's the case that if there were legislation, it could say that staff would be responsible for compiling something. And if that were the case, then staff maybe could use this as a base for having a final document. But I think that this is what we are working from right now.
Yeah, an ordinance could compel a city officer to develop and promulgate, a statement of tenants' rights and, things like that.
Okay.
Yeah. Councilwoman Larson has this document or? She is. Okay.
Back to life.
For clarification,
I think she's frozen again.
So that's a good point. I assume that because it was in the packet that it got out, but I will follow up, or I'll ask Addie to follow up with Councilwoman Larson. Can you hear us?
Oh no.
I will ask Addie to follow up with Councilwoman Larson just to verify that she did in fact get it. So, is there anything else on this topic that anyone would like to bring up or discuss?
You
Yes.
might want to consider like a FAQ thing too, some people won't read. I know it's not that long, but, just quick start, like that kind,
Yep.
You have things with documents because there are things that just, if you look at all that stuff, there's about 4 or 5 of those things that come up 90% of the time, and the rest is kind of like.
And also, even though most people are already here, most council members are already here at this table, I'll draft a legislative memo and share that at the next committee of the whole meeting with folks to just overview the issue and how this seeks to address that.
Are any landlords exempt from this?
Well, we haven't written anything, so I suppose we might be able to specify in legislation.
I mean, if you had one unit, would you be responsible for disseminating this out?
Is there a reason why we wouldn't want them to share this info with folks?
I guess the ordinances that we have on the books, are they for any size landlord?
Well, I guess that's a good question that I'll defer to the law director on.
Well, I haven't looked at that. I'm guessing that Elizabeth or Matt might know the answer off the top of their head to how Chapter 5321 impacts that question in terms of coverage. But I can
Elizabeth
certainly
or
look as well.
Matt, do you happen to know?
Yeah, so to my knowledge, there wouldn't be an exemption, certainly not in 5321. Now, the only area where I can think of an exemption would be the federal fair housing laws. There is an exemption under those for particularly small landlords. So
Right, but Ohio does not have that, like Mrs. Murphy's exemption, I think is what it's called, like
That's cute.
your stereotypical, small mom and pop landlord. It's called the Mrs. Murphy's exemption, and there's 4 units or less.
Right.
But Ohio revised code, like the Ohio civil rights law, kind of circumvents that. And so any fair housing discrimination based on, disability, gender, race, et cetera, is prohibited even for a landlord with a single unit.
And I think our Chapter 749 mirrors that reality as well.
So there would be no reason to separate it then by size? I mean, I wouldn't propose anything other than what's already in the books.
I was curious if I could just ask if Elizabeth or Matt had any thoughts on the impact of broadening the statement of rights and responsibilities to address both landlord and tenant, as I had mentioned. Because I don't have a strong opinion about it. It strikes me that sometimes it paints a fuller picture and actually could educate landlords as well. But having them send out their own rights and responsibilities might be different, and that might be something that would go on the website instead.
Potentially. Elizabeth or Matt, do you happen to have any thoughts on that?
yeah, I mean, I think in some ways it's almost like they're the inverse of each other, right? So a landlord's responsibilities tend to be a tenant's rights. So I think we could easily create something along those lines. The question would be how to disseminate it in a way that isn't confusing. Because I think if you were just putting it all in one document, it would get a little repetitive because
That makes sense.
like I say, they're going to be the inverse of each other to some extent.
Yeah, and as the law director mentioned, maybe it's a case of that's something that we want to, distribute only through the website. But would it be possible, Elizabeth and Matt, to compile something like that between now and our meeting in August?
Oh, certainly, yeah.
Okay, great. Thank you so much.
Sorry.
Okay. Anything?
No, we're happy, we're with you to the end on this, that's okay.
Anything else on this topic before proceeding to the next thing on the agenda? Okay, so Elizabeth and Matt, thank you again for joining us. Really appreciate it. I think everyone in this room is really appreciative of all the work that you put into it. And so we are going to move on to the next thing on our agenda now.
Do you want me to stick around for this?
No preference if you want to.
Thank you very much, everyone.
Thank you.
Thank you.
Six.
Okay. So the next item on the agenda is an update on the Racial Justice Task Force recommendations. So I sat down with Director Hanna and the Planning Director, and we talked about how we might be able to handle the recommendations. So Council President Kuda assigned them to our committee, the housing-related recommendations to our committee. And so in conversation with Director Hanna and Director Zanf, it came up that maybe we could address a couple of these in each of our housing meetings. So maybe 1 month we could address 1 or 2 of them. The next month we could do 1 or 2 more. They also noted that for some of them, it could be the case that we're able to address them without legislation. So for example, I think one of the recommendations was notifying people that they could be eligible for assistance. And so that was something that Director Zanf noted we could just do in-house and staple to our citation. So that seemed like a reasonable approach to me. So I think Director Zanf's intention is to look through the recommendations and identify a few that he could provide his thoughts on at our August housing meeting. Are there any questions about that approach? Okay, so other than that, I'd just like to make 2 notes. So one is that we have a housing meeting, another housing meeting at 5 p.m. on Tuesday, June 25th. And so during this meeting, the administration is going to provide an overview of the recent Western Reserve property survey. And they're also going to overview the city-owned properties that we have. And finally, provide an update on the Community Improvement Corporation, or CIC. And in addition to that, Councilwoman DeVito Russell and Judge Costello are hosting an event with the Legal Aid Society on Saturday, June 29th at the Noble Library from 10 a.m. until 1 p.m. So it's my understanding that there will be lawyers there who could help renters and I think even homeowners with housing-related issues that they encounter. So again, that is Saturday, June 29th at the Noble Library from 10 a.m. until 1 p.m. So that is all that I have on my list. Is there anything else that anyone would like to bring up while we're together? Councilwoman Larson? Okay, so with that, I will adjourn this meeting at 5:28 p.m.